I am going to fine you additionally $100 and assess court costs of $108 and a booking fee of $45 for a total, I believe that comes to $253. How much time do you need to pay that, or can you pay that in person today at the courthouse?
De nada, entonces voy a encontrar adicional a esto que deberá cubrir los pagos de $100 más $108 de costos de corte y la cuota de procesamiento de $45. En total son $253. ¿Necesita tiempo para poderlo pagar? ¿Podrá pagarlo el día de hoy mismo en la corte?
¿Podré pagarlo el lunes?
Can I pay it on Monday?
Yes, I will give you 30 days to pay it because we need the attorneys and I need to get the journal entry prepared, signed, and filed. So we may need to get that done before you can pay. And sometimes that takes up to 30 days. So I'm going to give you up to 30 days to pay that.
Muy bien, le voy a dar 30 días para pagarlo, ya que necesitamos tanto el abogado como yo que se firme la entrada ante bitácora, que se preparen los documentos, se completen y se firmen. Usualmente se requieren hasta 30 días para hacerlo, así que eso se requiere antes de que usted pueda pagar, por lo cual tendrá 30 días.
Ok, perfecto.
Okay, perfect.
If you call the clerk of the district court, she can tell you when and how to pay online, in person, or by U.S. mail. And her number is 620-583-8153.
Bien, si usted llama a la Secretaría de Distrito de la Corte, ellos le podrán notificar cómo pagar en línea, cuándo, ya sea también en línea, en persona o por correos postales de los Estados Unidos. El número telefónico al que deberá llamar es el 620-583-8153.
Perfecto, gracias.
Perfect, thank you.
You're welcome. Now, if you do not want to serve the jail time, make sure you understand and comply with the terms of your probation for the next 6 months.
De nada. Entonces, si no quiere servir ese tiempo en cárcel y ha quedado claro y desea no pasarlo ahí, tendrá usted que cumplir el tiempo de probatoria sin reportar por los próximos 6 meses.
De acuerdo, de acuerdo.
Agreed.
Condition 1, you are to violate no laws for the next 6 months.
La primera condición es que no deberá violar ninguna ley en los próximos 6 meses.
Bien, perfecto.
Fine, perfect.
Condition number 2, pay the total due within 30 days.
Condición número 2, tiene que pagar el adeudante total dentro de 30 días.
Bien, me comunico
Fine.
con el número.
Yes, I'll get in touch with the number.
Thank you. Condition number 3, keep the county attorney informed of your address and contact information.
3, mantenga al fiscal del condado o abogado del condado informado de su dirección e información de contacto.
Bien, perfecto.
Fine, perfect.
And that is all you have to do to keep from serving that 30-day jail sentence.
Y eso es todo lo que tiene que hacer para evitarle servir ese tiempo de 30 días en cárcel.
Bien, bien.
Fine.
Mr. McElhaney, anything further for the defense?
No, Your Honor. Thank you. Thank you, Mr.
Yes.
Dean.
Thank you. Did we set a review date, Your Honor?
We did not. Would you like to set a payer appear?
I do. Mr. McElhaney, given that we're just payer peer monitoring, do you wish to be shown as withdrawn from the case? You're going to stay in a break.
I'll stay in to make sure he gets it
Okay.
paid.
Sounds good.
Muy bien, entonces, su señoría, podemos establecer una fecha para presentar ya sea pago o compadecencia, solamente para monitorear. Señor McElhaney, ¿desea usted estar presente o retirarse ya del caso? Me quedo para estar seguro que se haya hecho el pago.
All right. So, Missy, when does he need to come back?
Did you say
About-
30 days?
I did.
How about August 28th at 11?
Muy bien, Missy, ¿para cuándo tendría que regresar él? Para el 28 de agosto a las 11.
So, Mr. Rios, you either need to have this paid in full or reappear in court August 28th at 11.
Bien, señor Ríos, entonces, ¿tiene que haber pagado en su totalidad o tendrá que presentarse nuevamente a corte el 28 de agosto a las 11?
Perfecto.
If it's paid, you don't have to be back. If it's not paid, you do need to be back, and we need to talk about how that may affect your probation.
Si paga, no tiene que regresar. Si no paga, tiene que regresar. Entonces tendríamos que hablar acerca de cómo esto va a afectar su probatoria.
Oh, bien, bien, de acuerdo.
It's fine, agreed.
Thank you. If there's nothing further, we'll be in recess, and Mr. Rios is excused. Before
Bien.
you go ahead.
Si no hay nada más, entonces entramos a receso para su caso. Señor Ríos, puede usted retirarse.
Bueno, muchas gracias por su tiempo a todos. Buen fin de semana.
Thank you. Thank you for your time, everybody. Have a good weekend.
You have one as well, sir.
Igualmente, señor.
Gracias.
Mr. McElhaney, before I let you go, how do you pronounce your last name?
McElhenney, you were close.
Well, the locals say McElhaney, but that's not quite the way you pronounce it, is it?
Well, that's the way most people pronounce it, but it's McElhenney. McElhaney's fine too.
McElhaney?
Yep.
Okay. All right. Thank you. I'll try to remember that because I know
Okay.
every time I say it the way it looks, I think that's not quite right.
Yeah, that's fine, Judge. Everybody have a good weekend.
Thank you.
You
You
have a great
too.
one as well.
Good to see you. You may go third. And Miss Garcia, would you mind checking to see if anyone else needs Spanish interpreter today?
Of course. ¿Alguien más en esa sala necesita intérprete en español para el día de hoy? No response, Your Honor.
How about Martin? Let's say Martin Riveres. Is he here today, Mr. Cooper? Do you know?
That is not my client, so I don't know.
Okay, and he's not until the 11 o'clock docket anyway. All right. Thank you, Miss Garcia. We appreciate your services as always, and you're excused.
It's always a pleasure. Have a wonderful day. Goodbye.
Thank you. All right, let's see, Mr. Cooper, do you want to go in any particular order or start at the top of the alphabet?
Judge, I just need a brief moment to talk to Mr. Dean just to confirm a couple of things about my two clients, and then we'll be ready to go, I think.
And that's Darlington and Hermrick are your clients?
Correct.
All right, thank you. Missy, if you would, please. Figure out where I put him. There's H. We are on the record in GW 2025 TR 611, State of Kansas versus Levi Matthew Hermrick. Please announce appearances.
Paul, you're muted.
Sitting here writing out journal entry notes. Your Honor, the state of Kansas appears by and through Assistant County Attorney Paul Dean.
Blake Cooper on behalf of the defendant Levi Hermrick, who appears in person.
And how does he wish to proceed today, counsel?
Your Honor, it's my understanding Mr. Hermrick will enter a plea to count 1, second offense driving while suspended. In exchange for that plea, the state will dismiss.
No, Dean, Paul, this is Hermrick, not Darlington.
Oh.
Thank you, Mr. Dean, for mixing one up for once. I do that.
Exactly.
This is the amended
right.
no DL in
regards
possession
to
case.
Mr. Hermrick, yes, Your Honor, she's got his driver's license valid, so the state will move to amend the no DL in possession. In exchange for a plea to that, the state will be recommending a $100 fine, court costs, $45 booking and processing, court can, should inquire in regards to appointed counsel fees. 30-day underlying 6 months non-reporting, if I haven't already repeated that a couple of times.
No, you haven't. Thank you. Mr. Cooper, that sounds like your agreement.
That's correct, Judge. And Mr. Hermrick did pay I believe a $503
cash bond.
$503 cash bond. So we would ask that those fines and costs be applied to that as well.
And Your Honor, I believe that 503 would equal $100 in fines, 108 court costs, 45 booking process, and then $250 appointed counsel fee.
Okay. So, Mr. Hermrick, how do you plead to the amended charge of driving without a driver's license in your possession?
I plead guilty to it, or no contest.
Okay, which do you want to plead?
Or
Guilty?
yeah,
Guilty, which means you admit it. No
that's
contest.
whatever. But the no contest.
Okay, so by pleading no contest, you don't want to admit the charge, but you don't want to deny it and take it to trial either. Is that correct?
Yeah. Yes.
Okay. Is anyone making you enter this no contest plea today by any threat or promise other than your plea agreement?
No.
Actually, this is poor Mr. Hermit. This is not an amendment. This is the original charge, isn't it? Or is this-
It was a
It was 8/2/35 amended date.
it was 8/2/35, and now we're amending it to 2/44, Judge.
Right.
Okay, so it is an amendment. All right. But in any event, it's the amended charge of driving without a license in your possession in this county on December 1st of 2025, to which you plead no contest, correct, sir?
Yes.
All right. And you understand you're giving up your right to trial. You'll be found guilty most likely and proceed to sentencing.
Yes.
All right, Mr. Dean, you have a factual basis to support this?
I can give one, but Mr. Cooper, would you guys stipulate based upon the narrative citation?
We would,
that the
yes,
fact
we would
base-
stipulate that there's a factual basis, Judge. The factual basis that we would stipulate to is that on or about.
Gentlemen, I have a probable cause affidavit filed December 5th, 2025. Would the state offer that?
That would
Yes,
supply
Your
the
Honor.
factual basis, Judge.
All right. We will accept that affidavit then as the factual basis to the no contest plea. This is an affidavit of Deputy Jeremiah, who was on patrol December 1st, 2025, and encountered the defendant and goes into detail. All right, based on the defendant's no contest plea, which I find is freely and voluntarily entered, knowingly entered, and the state's offer of this affidavit as a factual basis, I find it does support the charge and the plea. I find the defendant guilty. I will proceed to sentencing per the plea agreement announced earlier herein. Mr. Hermrick, are you hearing me all right?
Yes.
All right, your fine is $100. Your court costs are $108. You will be assessed the court costs as well as a booking fee of $45. And sir, do you work at this time?
No, I'm unable to work at the time due to my
Is it-
shoulder. I had a shoulder replacement and it was messed up from the doctor. So
All
I'm
right.
in the process of getting it fixed.
I will waive your attorney fees. And your sentence is 30 days in jail, but it is suspended so long as you successfully complete a 6-month non-reporting probation. Condition 1 is violate no laws during the next 6 months. Condition 2 is to pay the money owed of about, what is that, 253-ish? How much time do you need to pay that?
I'm going to take it out of the bond that I paid.
All right, I'm gonna give you 30 days to pay it. that's really giving the attorneys and me time to do your paperwork for the order for the clerk and time for the clerk to apply that and then send you any refund. So 30 days to pay, and to keep the county attorney, 3 is to keep the county attorney notified if you change any of your contact information such as address and so forth. All right, anything further, Mr. Dean?
Just a pay appear, which I believe that
Oh,
we
yes.
said it August 28th was the appearance date we were using.
Are we still using August, what, 28th was it? At what time, Missy? 11?
Yes.
All right. So, Mr. Herrick, you have to have that paid by August 28th at 11, or you have to reappear and explain why it's not paid and discuss any effect it may have on your probation. If you violate your probation in the next 6 months, it could be revoked and you could serve the 30 days. Mr.
Okay.
Dean, oh, that was you saying that. Okay. All right. But if it's paid, you don't have to reappear. All right. Anything further?
All right,
from
thank you.
anyone?
None from the state, Your Honor. Thank you.
All right. Thank you. You may go, Mr. Herrick. Mr. Cooper, do you want to take up someone else specifically, or you want me to pick?
Matthew Darlington, Judge, is my last client on this docket.
All right, and now we'll take up Matthew Darlington.
This would be the plea I was getting ready to announce it. Mr. Hemrick. That would have been very unfavorable to Mr. Hemrick.
So we're doing Darlington. On the record in GW 2025 TR 526, State of Kansas versus Matthew Keith Darlington. Please announce appearances.
Your Honor, the state of Kansas appears by its Assistant County Attorney Paul E. Dean.
Blake Cooper on behalf of the defendant Matthew Darlington, who appears in person.
All right, I understand there is a plea agreement in this case as well, gentlemen.
Yes, Your Honor. Mr. Darlington would plead to count 1, second offense driving while suspended. In exchange, state would dismiss counts 2 and 3. State would also, based upon that plea, recommend a $300 fine, 108 court costs, $45 booking and processing fee. That he be placed on, be given a 6-month underlying sentence, suspended for 6 months of non-reporting probation with all the typical terms and conditions of non-reporting probation, as well as setting an appropriate peer review date. And I would assume that the plea that would be offered and would be accepted by the state would be a no contest with a stipulation to a factual basis.
Okay. And Mr. Cooper? Anything further?
Judge, that's correct. I would only add a couple of things. The parties agree that Mr. Darlington has served any mandatory jail time at this point. He's served some time in, I believe it was May. In this case, he paid a $903 cash bond at that time, so he would ask that the fines and costs be paid by that as well.
Has he paid, do you think he served the full 6-month sentence?
5 days.
No,
Mandatory
no,
5
no,
days for the second offense, Your Honor. State
No,
would
I think
agree
he's-
with that.
Okay, hang on. I don't think I got it right. What's the underlying for count 1?
Count 1 would be 6 months, but there's a which states that
Oh.
requesting suspended, but there's a mandatory 5-day sentence, which I believe Mr. Darlington served approximately 2 weeks. So the state would agree that he's satisfied with time served, the mandatory minimum.
Okay. Anything else, Mr. Cooper?
No, Your Honor.
All right. Mr. Darlington, are you hearing us okay?
Yes.
Very well. How do you plead to count 1, driving while your license was suspended?
Yes.
You plead, how do you plead? Your attorney told me no contest. Is that
We
how
can't hear
plead?
you, Matthew. I don't know what you're gonna have to speak up or.
Yeah, no contest.
All right,
Okay.
by pleading no contest, you don't want to admit that you were driving while suspended in this county on September 26th of 2025, but you don't want to deny it and take it to trial either?
Yes, Your Honor.
You understand that even though you're not admitting this charge, you'll still be found guilty and you won't be able to appeal the conviction?
Yes, Your Honor.
Is anyone making you enter this no contest plea?
No, ma'am.
Is anyone making you waive your right to trial?
Nope.
All right. I will find that you are knowingly and voluntarily, that is, knowing what you're doing and doing it without force or coercion, entering this plea. And I will need a factual basis, which I understand there is a stipulation to.
Yes, Your Honor, we would stipulate to the affidavit.
And the certified driving record, Your Honor.
All right, we have a probable cause arrest report affidavit filed 9/30/2025 by the state, and I will accept that as partial factual basis. This is, again, a Deputy Jeremiah Andrews affidavit from when he was on patrol September 26th to 25 in Greenwood County, encountering this defendant driving a 2008 black Chrysler, indicating that his record was suspended, and I will accept the certified driving record as evidence. It is stipulated to. I do find the defendant guilty of count 1, driving while suspended, and I dismiss on motion of the state per plea agreement the remaining counts. I will follow the plea agreement. Now, Mr. Cooper, are you retained?
No, Your Honor. This is part of the
Okay,
contract.
court order. All right. And Mr. Darlington, where do you work?
I work at Sandlin Iron and Metal.
Is that a full-time job?
Yes.
And what do they pay you per month? Yep, remember? Do the math.
2,000.
2,000. And are you married or single?
I'm single,
Support
but
minor
I've been
children?
getting garnished, so it's more like
Okay.
Your Honor, that
15.
from a that I believe attorney fees, sufficient bond has been posted for the
Oh,
attorney
that's
fees.
right. Thank you for that reminder. You were going to pay that out of your bond. Thank you. I forgot. All right. So you're at this time, your fine on count 1 is $300. Your court costs assessed are 108, and your booking fee is 45. So that's a little over $350. How much time will you need to pay that? I'll tell you what, I'll give you 30 a day. I keep forgetting you've posted your cash bond. You want this paid out of your cash bond?
Yes, ma'am.
All right, I'm going to order 30 days to pay. And again, that's like I told the gentleman before you, that's probably more time just to get the journal entry on file than anything. But 30 days to pay. It will be paid out of the cash bond he posted previously. And any refund will be sent to him or whoever it goes to. Sometimes it goes to someone who posted it for you. You will be given a 6-month jail sentence. You will not have to serve that. I'll give you credit for that 5 days already mandatory served, credit for that time served against that. And then the 6 months will be non-reporting probation also. All standard conditions, call probation. As soon as this hearing is over, can you write down their number?
Judge, it's
Yeah, just
non-reporting probation.
Oh, non-reporting. Okay, I
Yeah.
did say, all right. All right, it's non-reporting probation. You won't have to report to a probation officer, but you do have to comply with the following probation conditions. Number 1 is don't violate any laws of any kind for the next 6 months. 2 is to make sure that you get that 300 paid out of your bond. Keep an eye on the clerk, make sure that gets done. And 3 is keep the county attorney informed if you change your address or any of your contact information. And I believe that covers it. Mr. Dean,
I think so, Your Honor, yes.
Mr. Cooper, anything further?
Judge, I didn't gather whether you assessed an attorney fee or not.
I'm going to waive the attorney fees.
Okay. All right. So the total that I have is $453 at that point. And
That
so
sounds-
Matthew, you'll just need to contact the clerk's office to make sure that that bond gets applied to your fine.
Do
You
you have
want
their
the-
number?
Yes, I do. It's 620
Give
58.
me 1 second. I need to find a pen. You said 620
Yes, and then 583,
583
then 8153. 1.
153.
Yes, if you call them, they'll talk to you, whatever you need to know about making sure that payment gets made out of your cash bond.
And that was pay or appear August 28th, Your Honor, at 11 again.
Missy, does that work? That he needs to either have it paid by August 28th at 11, or he needs to appear in court at.
Right, this is the one the cash bond's gonna pay.
Right, so
Yes.
it should get taken care of pretty
Okay,
quick.
but yes, we can set it on there.
All right, so right before that court date, you call and make sure that that's been taken care of, or you'll need to appear here, sir.
Okay.
But if it's paid, don't worry about the hearing.
What's the court date again? Just so I have that.
August 28th at 11.
All right, thank you.
You're welcome. If there's nothing further, Mr. Darlington is excused from these proceedings today. You may go, sir.
All right, you guys have a great weekend.
Thanks, you too.
You too.
We'll now be on the record in Ogle. GW 2026 TR 208, State of Kansas versus Christopher Shane Ogle. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paulie Dean.
And I'm here as well, man.
Does appear in person and pro se. Mr. Ogle, you're here on failure to yield to an emergency vehicle, an infraction that carries a $195 fine, no jail time. You're also here on count 2, operating a motor vehicle without registration or with expired tag. This is an unclassified misdemeanor. It carries a fine that could be as high as $2,500. Usually it's much less. It also has a 30-day to 6-month jail sentence, probation usually an option. But you do have the opportunity to hire an attorney. If you cannot afford to hire an attorney, you can apply for a court-appointed attorney, or if you wish, you can waive your right to attorney and proceed on your own behalf.
Could I propose a breakout session, man? Is that allowed?
Are you wanting to represent yourself then and speak to the prosecutor?
Yes, ma'am.
And Your Honor, I can let Mr. Ogle know that based upon the documentation he's provided, that I will be dismissing the vehicle registration citation, so just be leaving the fail to yield for emergency vehicle.
All right, so how do you want to plead to this sole remaining count of failure to yield to an emergency vehicle?
Ma'am, I will go guilty. I just didn't know the rule in Kansas, so I'll take that one.
All right, by entering a plea of guilty, you're admitting the charge of failing to yield on March 29th of 26 in this county?
Yes, ma'am.
You understand with the plea of guilty, you're waiving your right to trial. You will be found guilty and will proceed to sentencing today.
Yes, ma'am, that's fine.
Anyone making you enter this plea today?
No, ma'am.
All right, and are you pleading guilty because you believe you are guilty?
Yes, ma'am.
All right, I accept your plea and find you guilty of failing to yield to an emergency vehicle. Mr. Dean, any reason why I shouldn't assess a $195 fine and 108 court costs?
No, Your Honor.
All right, that will be the order of the court, $195 fine, 108. That is a pretty high fine. Do you want some time? And if so, how much to pay that?
Ma'am, just 2 weeks would be fine.
Yeah, it's about $303. 2 weeks would be fine.
Yes, ma'am.
All right, that will be order of the court to pay within 2 weeks or
I just asked that we set it for 30 days with that August 28th. At 11. Don't have any doubt that it'll be taken care of by that date. Mr. Ogle, what we do every time we have a hearing is prepare something called a journal entry, and this would be a journal entry of plea and sentencing. Simply just gonna note the court issued a fine, court costs, give 30 days to pay, set a pay or appear for August 28th, 2026 at 11 a.m. Obviously, pay or appear means just that if you've paid it, you don't need to appear. I don't have that journal entry prepared right now. If you want me to, I can email it to you. Give me an email address so you can review it ahead of time. But given the limited nature of what the court ordered, would you just waive signature? That way I can get it on file and then you
Yes,
can
sir.
pay. Okay. Thank you.
very well. If there's nothing further, we'll be in recess until August 28th at 11. But if you haven't paid by then, you don't have to reappear, sir.
Yes, ma'am. Thank you very
Thank
much.
you,
Have
Mr.
a good
Ogle.
one.
Good luck with everything, sir.
Thank
And
you.
do you need the telephone number to call the clerk about payment?
No, ma'am.
All right.
I can
Thank
go
you.
there. Thank you.
You're welcome. You may go, sir.
All right, thank you. Bye-bye.
Thank you. And I believe that concludes the 9 o'clock portion.
It finishes it on, from what I have on my list, Your Honor. I do see that we're 5 after 10 right now for the 10 o'clock docket, but I'm gonna need to take a short break.
Please do so. We're on a short break before
Thank
we
you.
begin at 10 o'clock. You're welcome.
Blake, do you need any breakout rooms?
This is Moody for
For State of Kansas versus Scott D. Owen, please announce appearances.
Your Honor, State of Kansas appears by and through Assistant County Attorney Foley Dean.
Your Honor. Scott Owen appears via Zoom and by and through counsel Robert Moody.
How does he wish to proceed today, Mr. Moody?
Your Honor,
Judge,
go ahead, sir.
we do have an agreement.
Okay,
The insurance charge has previously been dismissed. Mr. Dean has agreed to dismiss the ignition interlock count as well in exchange for a plea to the lane change violation.
And Your Honor, I've been provided proof of that the ignition interlock had been installed in one of Mr. Owen's vehicles. So dismiss
so
with proof as to that charge.
so plead to count 1 and dismiss 2, and 3 is dismissed for proof already. So
Correct, Your Honor.
where are you, Mr. Owen? Then where'd you go?
Right
you are.
here. Yep.
Okay. Mr. Owen, how do you plead to the remaining count of improper driving on a laned roadway in this county on February 5th of 2026? I think they're basically saying that you kind of lingered in the left lane, maybe.
Yes, ma'am. I plead guilty.
Let me pull that citation up to make sure that that is what I think it is, as I understand it. Yeah, just a left lane violation. You were in the left lane too long. You said guilty.
Yes, ma'am.
Anyone making you enter this plea today by any threats or promises?
No, Your Honor.
You understand you're giving up your right to trial,
Yes.
and this is an infraction. In your own words, what'd you do?
Stayed in left lane too long.
All right. I accept your plea and find you guilty. Recommendations, Mr. Dean?
I apologize, Your Honor. We don't have this one come up all that often. I'm not sure I've got the scheduled fine for that, but
I think
it's just an
that's-
infraction.
I think it's a 75, if I'm not mistaken. Mr.
I believe that's probably correct.
I think that's correct.
I just checked the statute. It was not that fine schedule was not referenced in the statute, so.
Okay. Well, $75 fine, 108 court costs. How long will it take you to pay that, Mr. Owen? With
I can
30
pay it.
days?
I can pay it today.
Okay, well, if you pay today, I think you have to pay in person. Otherwise, if you want to pay online or through mail, I'm going to give you 30 days for good measure. That's really more for us to get the journal entry on file in case the clerk needs it. But if you want to call the clerk today and see about trying to pay it, I can give you the number. Are you able to write it down?
Yes.
It's 620-583-8153. Mr. Owen, did you
Thank
get
you.
that?
Yes,
All
Your
right.
Honor.
All right. Anything further on this matter, Mr. Moody?
Just real quick, Mr. Moody, given the limited nature, and I think you've seen my kind of fill in the blank journal entries, are you good with waiving signature so I can get that filed and your client can get it paid sooner rather than later?
I am Mr. Dean. Thank you for that.
Obviously, if you think I made a mistake, let me know and we can always do an auto doc. So,
Sure, absolutely. Thank you for doing that.
yep. You have a great
Thank
day.
you. Mr. Moody, if there's nothing, Mr. Moody, if there's nothing further, you and your client are excused from this hearing at this time.
Thank you, Your Honor.
You're welcome. All right, Mr. Clark, are you ready to proceed?
Yes, Your Honor. This is the Cody Fullhart case. It's
Fullhart?
one count of DUI. I communicated yesterday with Mr. Dean. I'm pretty sure we'll get this resolved on the basis of a plea, but he needed to review the file again before making a recommendation. So I think we may just need to set it over one more time.
Okay, we're on the record in GW 2026 TR 228, State of Kansas versus Cody Don Fullhart. Paulie Dean for the state, Attorney Kenneth M. Clark for the defendant, Cody Fullhart, who also appears in person, Mr. Clark?
I believe so, yes.
I'm
Mr.
here.
Fullhart? Where are you?
Yes, ma'am.
Okay, there's Cody D. Cody Dawn. Okay, I get it. Can you start your video? Great. All right, so you're asking for how much time to continue this to, Mr. Clark?
30 days should be more than adequate, Your Honor.
Okay,
Yes.
Missy, what do you have for about a 30-day continuance at the defendant's request?
We could do August 28th at 9.
Counsel, does that work? By Zoom?
That works for me, Your Honor.
Very well, Mr. Clark, this is continued at your request to August 28th at 9 a.m. You must reappear by Zoom at that time with your counsel, ready to proceed. I will continue you on any bond that you have made with that order to continue. Any questions, Mr. Fullhart?
No, ma'am.
All right, thank you. You may go, sir.
Thank you.
Thank you, Your Honor.
Thank you.
Welcome.
Have a good day, everybody.
Mr. Clark, you don't have anything else, do you? On this docket? No? All right, thank you, sir. We'll be in recess. Mr. Cooper, do you have any you want to take up? Or Jeffrey Jones? Oh, that's 11. Mr. Cooper, do you have any special order or anything you want to take up?
Judge, I will need a breakout room with Mr. Dean first.
Very
So
well.
we can kind of get things organized and then we should be able to proceed.
All right, Mr. Dean, are you available to do that if Missy puts you in a breakout room?
Oh, let me check with my assistant.
Okay.
Yes, I think so.
All right.
They're wanting to get on and they'll be
All
on
right.
here in a second. So if that'll take
Thank
me
you.
1 minute.
That'll be fine, thank you.
Okay. Judge, I would like, if we could, to take up, we have a number of, a few continuances that I'd like to take up first, and then we have some pleas for you.
That's fine. We'll
Okay.
just name them.
Orlando Patton,
We will be on the record in GW 2026 TR 231, State of Kansas versus Orlando A. Patton. Please announce appearances. Mr. Dean is muted, so Paulie Dean for the state. Gotcha. And
Keeps me muted when I come out of breakout room. I did catch up, apologize.
same here, I understand. And Blake Cooper for the defendant, who also appears in person. Now, you said this is Orlando Patton we're taking up, so right?
that's correct, Judge.
So we also have case number GW 2026 TR 482. That's GW 2026 TR 482 and GW 2026 TR 231.
That's
So-
correct, Judge. At this time, the defense is requesting a continuance. I've spoken to Mr. Dean. There's no objection by the state. We're asking for a date in September.
Mr. Dean, no objection, is that correct?
That's correct, sir.
And that's both cases, Mr. Cooper?
Yes.
Missy, can you accommodate us?
Yes, I have September 11th or September 25th.
I
Mr.
would
Cooper?
imagine I have both of them open for, well, I'll tell you what, that was September 25th is going to work best for my calendar. Is that okay?
At what time, Missy?
10 o'clock.
Okay, if there's no objection, this is continued at the defendant's request to September 25th at 10 o'clock. Mr. Patton will be continued on both his 5,000 professional surety bond in the 231 and in his 1,000 OR in the 482. Mr. Patton, added conditions are that you reappear with counsel ready to proceed September 25th at 10 a.m. Any statements or questions about that?
No, ma'am.
All right. If there's nothing further in these matters, Mr. Patton is excused from these proceedings.
Thank you.
Thank you, sir. You may go at this time.
Okay.
Judge, could we take up Michelle Turner?
Very well. We'll be on the record in GW 2026 TR 294, State of Kansas versus Michelle Lee Turner. Please announce appearances.
State of Kansas appeared by and through Assistant County Attorney Paulie Dean.
Blake Cooper on behalf of the defendant, Michelle Turner. She appears in person.
And any announcements at this time concerning the Turner matter?
Your Honor, parties are in discussion about this case. There's some fairly significant discovery that needs to be reviewed. We're asking for that September 25th date on defense continuance.
Any objection, Mr. Dean?
None, Your Honor.
Continued at defendant's request without objection to, what was that date, 9/25, Missy?
Yes, at 10 o'clock.
Yes, please.
Ms. Turner is continued on her bond with the added condition that she reappear September 25th of this year at 9 a.m. Wait a minute, you said 10 o'clock?
Yes, please.
10 o'clock. Make sure you stay available and with your attorney because you'll need to be ready to go with your attorney at 10 o'clock, September 25th. Ms. Turner, and I do take this DUI very seriously. I trust you will as well. And don't be doing any illegal driving or driving under the influence. So no alcohol or drugs. Continued on your 2,500 professional surety bond. Come back September 25th, 26th at 10. Otherwise, Ms. Turner, do you have anything you'd like to say or just confirm that you heard that?
I heard it.
All right, you may go at this time, Ms. Turner.
Thank you.
You are welcome. Thank you. Mr. Cooper?
Judge, could we take up David Mannion?
Okay. Ms. Turner, you're welcome to leave if you wish. Thank you. On the record in GW 2026 TR 126, State of Kansas versus David Andrew Mannion, please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paulie Dean, Your Honor.
Blake Cooper on behalf of the defendant David Mannion, who appears in person.
How does he wish to proceed, Mr. Cooper?
Judge, I'm not sure which way how you'd like to handle this. This is going to be a case where I want to get a motion to suppress on file. I don't know if you want to set a motion date today or if you want to set a deadline and then set the motion date at a later date. However you decide you want to handle it, Judge.
Well, as long as the motion is filed, I have no problem with that. Setting it today, that is.
It's not filed yet.
Okay, I understand. And some attorneys never get them filed, and then we have a date. And that's why you're saying what you're saying. You know, I've seen that from others. All right.
I hope I'm not in that
Why don't
group.
we just push it out to that September 25th, 10 a.m. We'll see where we're at with things.
Okay, that sounds fine.
Well, that's going to make this case get some age on it, Mr. Dean, if that motion to suppress is, depending on how that comes out.
What I will try to do, Judge,
Well,
is
if the court wants to set a deadline for the date to file it prior to that date,
All
state
right.
has no objection.
All right. So you said the motion to suppress should be set for what date? Did you say the 9/25, Mr. Dean?
Yes, and if it looks like we need to, we can always come back and between now and then and request a special setting if it looks like it's going to take.
All right. So Missy, when are you going to set that for 11? September 25th, if you can.
Well, it doesn't matter, whatever time. The 10 o'clock usually gets pretty full, and I don't know if we'll have time to actually do a motion to suppress.
All right, that could take a while. Well, sometimes I put those on Wednesdays at 1:30, which I don't know if council either one of you.
No,
would do.
that's Butler County.
That's Butler County, strike that.
But we
Okay.
could do a special setting if you want to go ahead and set it for an actual evidentiary motion.
Gentlemen, what do you want to do?
Sounds good. Let's just do it.
yeah.
Got a
I gotta
hearing
go
date?
get a calendar real quick here. I apologize.
Do we want to go out to September, or do we want to try for a date in August?
I would prefer September. My August is getting pretty packed at
Okay.
this point. If that's okay, Judge.
Fine with me, as long as it's okay with Mr. Dean. He seemed to be okay.
All right. What are we looking at?
Well, I think, Mr. Cooper, you just made a suggestion of which month?
Sometime in September would work best for me. I think August is getting pretty full.
Okay, and Missy, what do you suggest?
A Tuesday morning or a Friday. I do have September 4th, Friday, all day open. That's the Friday before Labor Day.
I've got a domestic trial that day.
Okay.
No, let's not do that.
What about Tuesday, September 8th in the morning?
Fine. I could do it starting at 10:30. I've got commission meeting in Greenwood County at 9, but we're generally done by then.
Day of the week is.
That's a docket day for me on Butler County Sync. I'm sorry, and I've got a few cases that morning already set.
What about September 15th in the morning? That's a Tuesday.
Could we start at 9?
I can't. I could start at 10 though.
I have a hearing at 11. But I think you think we'd be done in an hour, Paul. I don't. It's just probably one or two witnesses. I don't know if we would be.
Well, is it just about the stop or is it beyond that? You're muted now, Blake.
It's going to be more about the, if I remember right on this one, this is the one that's more about the probable cause. And
Well, I would agree. It
it'll be a
appears
little
like
more involved.
I think there'd only be one officer. Let's try. I think we'd probably try to get through that.
9:15 at,
No, I thought we were talking, I was talking about 10 or after. I think, Blake, you said 11?
which day?
No, I said I could start, if we started I have a hearing that starts at 11. So
Oh, I got you. September 15th at 10 o'clock, Your Honor.
Folks, that might be pushing you. Missy, what's your next available open date, if any?
It would be September 18th. That's a Friday. I have all day available.
I'm available all day.
I am as well.
Let's put it in the morning then, in case that somebody needs a Friday afternoon off or wants one off. How about 9 a.m.? Would that work?
Sounds good.
Works for me.
All right, 9 a.m. and you think an hour, but it might take longer. So, Missy, if we can avoid getting that too full, let's do it.
Yes.
Thank you. All right, Mr. Mannion, this is being continued at your request to 9 a.m., 9:18 by Zoom again. You
Yes, Your Honor.
You must be back here with your attorney ready to proceed at that time. And you'll be continued on your bond with the added condition that you reappear at that time, and that's the $2,500 professional surety you posted on 2/28 or 26.
Understood.
Okay, if there's nothing further, Mr. Mannion is excused from today's proceedings.
Thank you, Your Honor.
Thank you, sir.
Judge, I think at this time I do have Robert Goodrich here. He may be under that Samsung number.
Robert
not sure.
Goodrich, are you here? If you are, you need to click on your little microphone with the line through it, that little red
Your Honor,
microphone.
Apologize. We're trying to bring him on. I'm gonna get this calendar back to my system.
Yeah, go ahead while we try to do that.
Tell him you're there. Can you hear me?
I can hear you now if you click on the little camera, red camera with the line through it so I can see you.
I don't
There
see
ain't a camera.
There's no red camera. There's no
Are you
camera
on
at
a
all.
telephone or a computer?
Telephone.
On a cell phone, if you run your
my
finger
video.
down the side of the bottom, do you see it?
How about
There it is.
Gotta flip it.
Okay.
How do you flip it?
We got you.
There we go.
We are on the record in Goodrich, 2026 TR 117, State of Kansas versus Robert L. Goodrich. Paul E. Dean for the state, Attorney Blake Cooper for the defendant, Robert L. Goodrich, who appears in person. That is you, Mr. Goodrich?
Yes.
All right, and the announcements, Mr. Cooper?
Your Honor, this is another one. We're working on getting some things done for the state. And so we're asking for that September 25th at 10 a.m. date.
Missy, can we do September 25th still at 10 a.m.? All right, Mr.
Yes.
Goodrich. This is being continued at your request to September 25th at 10 a.m. You must be back here with your counsel by Zoom at that time. That is an added condition that you reappear then, added to your bond conditions, that $2,500 professional surety you posted February 20th, 2026. You understand you must be back at that time, sir?
Yes.
All right. And you might want to make sure you're on time if possible. You can always come to the courthouse if you have trouble working those devices.
Okay.
If there's nothing further, you may leave the hearing now, Mr. Goodrich, as we will be in recess on your case.
Okay. Thank you.
You're welcome.
Judge, I have Jonathan Irving. He's at the courthouse.
Very well. Security, if you can help Mr. Irving. No, Mr. Irving, is that you with the cap on?
Yes, it is.
Normally in court, church, and certain places, we take our caps off. Thank you. I appreciate you doing that. We are on the record in GW 2025 TR 639, State of Kansas versus Jonathan T. Irving, Paulie Dean for the state, Blake Cooper for the defendant who appears in person. Mr. Cooper, any announcements?
Your Honor, this is a diversion case. Mr. Irving has turned in his diversion paperwork. I have it at my office and I have signed it. I need to get it over back to Mr. Dean's office today. And so the idea would be that Mr. Irving would be starting diversion as soon as Your Honor orders it and is able to sign the paperwork. So I don't know if you want to move it over to that September 25th date, but the paperwork should be done in the next day or so.
Any objection to that, Mr. Dean?
Actually, could we just look at this real quick on August 28th since everything
Okay.
should be done?
Sure.
August 28th at 9 a.m., 10 a.m.?
Probably 10 a.m. just to fit with Blake's, but I mean, it basically should already be off the docket by then since they're
Okay.
sending it now. Does that look okay, Missy?
Yeah, is it for diversion control?
Yes.
Yeah, that'd be fine.
All right, Mr. Irving, if your attorney does not, well, I'm going to put it this way. We're continuing this at your request to August 28th at 10 a.m. If your diversion is completely filed by that time, check with your attorney. He may tell you you don't have to appear. Because Mr. Cooper, you understand that if it's filed, he doesn't have to be here, right?
Correct.
All right. So do you understand what I just said, Mr. Irving, or do you need me to repeat it? I can sure do that.
I understand.
All right. Just stay in touch with your attorney. And this is continued again at your request to August 28th at 10 a.m. as an added condition to your existing bond, which I am continuing. You may go, sir. Thank you.
Thank you.
You're welcome.
And then, Judge, I have two that I believe will be for plea. Could I speak to Tizzy Russell first and then Avery Martin?
We will, Ms. Russell, watch your computer for an invitation to a breakout room and click on it so you can talk privately with your attorney, Mr. Cooper. Missy, would you please put them in the breakout room?
Your Honor, since he's got two conferences, I will be right back.
Sure. Missy, did we take up George Vincent Johnson yet?
No.
Okay. George Vincent Johnson, are you here? We don't have Russell either, do we?
Yeah, she's in the breakout room with Blake Cooper right now.
I thought that was Miss Martin.
No, Miss Martin's here also. But I think he wants a breakout room with Miss Martin now. Is that correct?
Yeah. Very short breakout room with Ms. Martin, if I could, please.
Okay. Okay, Mr. Dean, Mr. Cooper is back. Are we ready to cover a couple hearings?
We are, Your Honor. Let's start with Tizzy Russell, please.
We are on the record in GW 2026 TR 242, State of Kansas versus Terzitha Star Russell. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paulie Dean.
Blake Cooper on behalf of the defendant, Terzatha Russell. She goes by Tizzy, Judge.
Thank you. And how does she wish to proceed today on this speeding and ignition interlock violations?
Your Honor, the state will be dismissing, as proof has been provided, the ignition interlock charge. My understanding, Ms. Russell will enter a plea to the speeding, whether it be guilty or no contest with the stipulation to the factual basis. And then that would just leave scheduled fines and court costs.
Very well. Is that right, Mr. Cooper?
I believe there
correct, Judge.
is likewise a booking and processing fee due to the way
Okay.
it was originally charged, which would add an additional $45.
Okay. Miss Russell, how do you plead to the remaining charge of speeding 81 and the 65?
No contest.
You're not admitting the charge, but you're not denying it, wanting to go to trial either?
Right.
And you understand you can't have a trial if you want and deny the charge.
Correct.
All right, and by pleading no contest, I am finding the defendant guilty as charged with the citation and notice to appear offered as the factual basis is what the evidence would show at trial. Is that the stipulation, Counsel
Yes, Your
Cooper?
Honor.
All right. Defendant is found guilty and will be assessed the scheduled fine. Scheduled fine for 81 and a 65 is, it looks like $81 plus 108 court costs. And because of the charge that was dismissed that she had to be booked on, there is a $45 processing fee. Miss Russell, do you work?
No, ma'am.
Okay, I will waive the attorney fees, but you will be responsible for, looks like about $134 if I did my quick math right. But can you pay that today at the courthouse?
It's $194, Judge.
Is it 194? Wow,
Yeah.
that was really off. Yeah, that would make sense with an 81. Thank you, Mr. Cooper. So she did
1 plus 108 plus 45.
108, 81, and 45.
No, I'm
Well,
sorry.
that's actually not correct.
It's 234. Excuse me. You had it at 134. It's 234. Pardon me.
Oh, and
None
I
of us
didn't
can do
carry my
math.
one as my grade school teacher.
Yeah, that's what I didn't do that either.
Okay, all right. Well, Miss Russell, I think it's 234. The clerk is the absolute person to say this is what it is and whatever she says. I try to give you an idea so you'll know, but it is the scheduled fine and court costs and booking fee. Now, how much time do you need to pay that, or can you pay that today?
Probably about 30 days.
All right, I'll give you 30 days. I'm going to set what's called a pay or appear. You either have it paid by this date or you have to come back to court. No, you'll probably have to pay it by this time or you'll just get your license suspended. You won't have to come to court. I don't think I need to set a pay or appear, Counsel. What do you think? She either pays it or her license gets suspended.
That's fine with me, Your Honor.
Okay. All right, but do check with the clerk of the district court for payment arrangements if you need to, like how to pay online, how to pay by US mail, etc. And her number is 620-583-8153. The clerk is the official gatekeeper of the money changers around here, so she knows how all that needs to be done. So please call her.
Will
And
do.
if there's nothing further, we'll be in recess on Michelle Turner.
Miss Russell, Your Honor.
Oh, was that, okay, I had Martin and Russell, but I thought that was Miss Russell.
That was Miss Russell. You just said Miss Turner. So
Oh, well, yeah, I looked down. Sometimes I look one row down. I know better. I just happened to fall on the wrong line. Thank you for correcting. All right, so now we're ready for Miss Martin.
that's
Miss
correct,
Russell.
Judge.
I
You
can
may
go now.
Yes, Miss Russell.
Thank you.
You're welcome. We're now on the record in GW 2026 TR 295, State of Kansas versus Avery Lizette Martin. Please announce appearances.
State of Kansas appeared by and through Assistant County Attorney Paulie Dean, Your Honor.
Blake Cooper on behalf of the defendant Avery Martin, who appears in person.
Announcements, Mr. Cooper.
Your Honor, we have a plea in this matter. I don't know if Mr. Dean wants to announce it.
Sure. Your Honor, the plea agreement's as follows. The state will dismiss count 1, no insurance, and count 4 in exchange for pleas to an amended count, or not an amended count 2, just count 2 as charged, which is the registration violation, and amended count 3 to no license and possession violation of 8-244. In exchange for those pleas, the state would be recommending a fine of $50 for count 2, a fine of $300 for count 3. Count 1 was dismissed with proof. Recommend a controlling sentence of 30 days, suspended for 6 months of non-reporting probation, 108 court costs, $45 booking and processing fee, with court to inquire in regards to reimbursement of attorney fees and to set appropriate hearing date.
All right. Now you said, did you say you're amending that to 8235? That is the no driver's license.
8244. 8244.
8244, no valid driver's license.
I think it was a charge.
No, 8244 is no DL in possession. And yeah, we're amending it to that.
I believe it was originally charged as 8235. Right?
8235 is not the no driver's license in possession?
No, that's 8244. Right? 235 is no valid DL.
I think it might be the other way around. I'll let Mr. Cooper look and take your word for it, but
No, it's charged currently, right? I'm looking at the complaint, Judge. No valid driver's license, KSA 8235 is
I
what
don't think that's filed right.
I'm positive it's right.
Yeah.
And I'm positive 235 is no valid driver's license in possession. So let me look just to satisfy myself, since you're both kind of ganging up on me there, telling me I'm wrong. So 230. 8235, no driver's license, B misdemeanor. Mm. 244, license to be carried and distributed upon demand, and that's what you're amending it to.
Correct, Your Honor.
Well, I concede, folks. Okay. All right. So Miss Martin, how do you plead to, that leaves her with count, you dismissed count 1 or not?
Yes, count 1's dismissed. It's pleaded count 2 and 3. And count 3 being the amended count.
Okay. I'm going to pull up the charging document, not just the summary. And that's Miss Martin in the red sweater with the orange pencil, is that right? That's you, Miss Martin?
Yes, ma'am.
Yep. All right, Miss Martin, the count 2 registration offense has been amended to operating a motor vehicle without a valid driver's license in your possession. How do you plead to that amended charge?
Guilty.
Folks, I'm sorry, I'm struggling with that because as I pull up the actual charge, Avery Lizette Martin, count 2, in 26 TR 295. That's what we're all on, right?
Yes, Your Honor.
You're amending a registration charge.
No, count 2, she's pleading as charged. Register.
Oh, okay.
Count
Okay.
3 is being amended from no valid driver's license to no driver's license in possession, 8244.
So she's pleading to 2 charges, not just
Correct.
one.
Yep.
Okay. I mean, you could amend it like that, but I thought that was unusual. Okay, to count 2, you're charged with a registration offense that on or about the first day of April 2026 in Greenwood County, Kansas, you did unlawfully and knowingly drive a motor vehicle without a current registration. It may have been an expired tag, but it just says without a current registration, an unclassified misdemeanor. How do you plead to that charge?
Guilty.
And by pleading guilty, you're admitting that you were driving without valid registration.
Yes, ma'am.
What was wrong with your registration?
The registration on the car I was driving, there wasn't one. We have stickers, and I would have had to go back home to get the sticker in order to put on the car, so there wasn't one.
So, but an improper display, Your Honor.
Okay, and where is home?
Texas.
Okay, so you did not have a valid current Texas sticker. You had the plate, you just didn't have the sticker, and that is required. Okay. Now, count 3 is filed as no valid driver's license, and it's been amended to no valid driver's license in your possession on April 1st of 2026. How do you plead to the amended count 3?
Guilty.
Are you pleading guilty because you are in fact guilty in your opinion?
Yes, ma'am.
Okay, so you're admitting that you were driving a motor vehicle on April 1st of 2026 in Greenwood County, and you did not have a driver's license in your possession.
Yes, ma'am.
A valid one anyway. All right, I will ask you, is anyone making you enter these pleas today by any threats or promises other than your plea agreement?
No, ma'am.
You understand you're giving up your right to trial, will be found guilty, and will proceed to sentencing.
Yes, ma'am.
All right. I find the defendant has knowingly and voluntarily entered her plea of guilty to counts 2 and amended 3, and I find her guilty of same. And just for good measure, counsel, would you go over those recommendations again since I've...
Yes, Your Honor.
Okay, thank you.
The state will be recommending in any event per the plea, 30 days underlying sentence in the county jail, suspended for 6 months, non-reporting probation, court costs of $108, booking and processing fee of $45, a $50 fine on count 2, a $300 fine on count 3, court to inquire as to whether or not attorney fees should be reimbursed, as well as setting a proper pay or appear date. The conditions of non-reporting probation should include the payment of costs and fines as directed. Keep the county attorney's office notified if there's any address changes during the time period of non-reporting probation, and no law violation.
Now, did you recommend it? What was the underlying sentences you recommended on those? I heard the...
Just 30 days on
days.
count 3. I'm not recommending any sentence on count 2.
All right, thank you. And that is your understanding of the agreement, Mr. Cooper?
Yes, Your Honor.
All right, Ms. Martin, at This time on count 2, your fine is $50. No jail time. On count 3, $300 and a 30-day jail sentence that will be suspended in lieu of a 6-month non-reporting probation. The 6-month probation requires that you violate no laws as condition number 1. Condition, and that includes Texas, Kansas, federal, city, municipal, county, any laws. Don't violate any laws during the 6 months. And then pay the money owed, which includes the $50 fine, the $300 fine, $108 court costs, $45 a booking fee. Now tell me what kind of work you do.
I nanny right now because I'm about to start school.
I will waive the court-appointed attorney fees, but you're going to have about a little over $500 in fines and costs. Do you need some time to pay that?
Yes, ma'am.
How much do you think?
Is there any way I could get 60 days?
Well,
How about
certainly
90 days, Judge?
Sure, 90 is fine. Okay, I'll give you 90 days. You'll either need to have that paid or reappear by a certain date that I'm about to give you. Missy, when will that be?
October. October 23rd at 11.
Okay, have that paid by October 23rd at 11 or be back here in court.
Yes, ma'am. Thank you.
And pay that to the clerk of the district court. You are welcome.
Thank you.
You're welcome. All right, you may go at this time. We'll be in recess. Counsel, did George Johnson show up? I have a George Vincent Johnson that we ran over.
I have not seen Mr. Johnson, Judge. If you would, maybe you could move on to another. Give me a chance to call him. I haven't had a chance to call him this morning and see what's going on.
Okay, well, Jeff Jones probably would love to have you take a break and take up his case. So, Mr. Jones, you've been there a while. Who are you here for? Is it Hirschberger?
You're muted, Mr. Jones.
You've got the dreaded mute button on.
Unmuted. We're actually on Hirschberger on the 11 o'clock docket set for a trial.
Oh, you're early. Okay.
So that obviously would take quite a bit of time, make all these other people wait.
Yeah, we'll wait on Hirschberger. I bet that's what Deputy Fisher's here for too. Thank you, Mr. Jones. I wish I could have helped you out. Let me look for
Your Honor, while you're checking who all else is here, can I have a quick breakout room with Deputy Fisher? I believe he may have been having some technical issues that my office notified me of, and I need to see if we can get those corrected before the trial.
Okay. Excuse me, Missy, could you please put Deputy Blake Fisher and Mr. Polly Dean in a breakout room? And then I happen to notice Jessica Morgan's here. Miss Morgan, who are you here for?
Your Honor, I am here on Robert Williams.
Robert Williams. Well, maybe we can get him next. Is he set for trial? Hopefully not.
Your Honor, it's a warrant to show cause. However, I have been informed by the clerk's office that he is trying to get the Zoom link. However, the court has ordered for him to be in person as it is a warrant to show cause. So I just want to inform the court that you have already ordered him to be here in person.
Okay, because he's had some issues before. So are you able to tell him that, or have you told him that?
I have not been in contact with him.
Missy, you probably haven't had contact with him if he can't get through to us with his machine.
I haven't, but the clerk's office had said that he had tried to call, but since he was ordered to be in person, they didn't send the Zoom link out to him.
But did they remind him he was supposed to be in person?
I think so, but he said that his attorney sent him a letter that said it was by Zoom, so he didn't know he was supposed to be in person, but we have in the notes that he was ordered to be here in person at the last court date.
Okay, well, we better be here.
but I can, if you want me to, I can send the Zoom link to him so at least he can get on
Why
and.
don't you go ahead and do that, because I think that is legitimately confusing when we send them to send them the Zoom link, and I think we just do that routinely. We have a form and it goes out, but I can see
Well,
where that.
we don't send
But the clerk, I say we as a system.
no, the attorney might
Oh, the
send them
attorney
out.
did that. That's a
That's what he
difference.
told us, which, and I'm sure they probably do, because most of them are by
Who's
Zoom,
his-
except show causes. I mean, they're always supposed to
Oh,
be.
they're always, that's a local court rule, yes.
Yes.
And he has 2 cases for show cause, so. Yeah, Blake Cooper, could you come on here for a minute? Or are you still trying to find that other client?
I'm still trying, but are you talking about Mr. Williams?
Yes, he's saying that your office sent him something to say he could appear by Zoom, and I told him to appear in person because it's 2 show causes, and that's the local court rule. I can understand the form could go out.
Well, Judge, that's probably is our fault. It does look like I sent out a June 9th letter to him about today, and it does say it would be by Zoom. I'm sorry.
I understand how that happens. I was thinking maybe the clerk had done it until Missy corrected me. Can you get him here, or do you want to put him on?
Let's see. He looks like the letter I sent went to Emporia, so I don't know how.
Yeah, that's a ways away. Okay, well, I'll just put him on. Oh, good. I've got you both on here. Missy, stick him on here, if you would, please.
Okay, I'll send the Zoom link out to him and see if he'll log in.
Yeah, we'll do that. Mr. Dean?
Sure.
We had told Robert Scott Williams on his 2 warrants to show cause to be here. I had personally told him to be here at the courthouse because that's local court rule on show causes. Inadvertently, Mr. Cooper sent out his standard form that told him to be here by Zoom. I understand how that happened. He's telling somebody he's not here because he can be by Zoom. I think he's telling his court service officer that. Do you want to take him up by Zoom, even though he's supposed to be here in person in case he gets revoked?
I feel like that's a trick question. You're asking me if I'm good with violating your order.
Well,
Judge, another
I'm
option
fine.
would
If the
be
court's fine to proceed that way, I'm fine to proceed that way.
okay.
But I'm also good with the idea to reset it so he's here in the courthouse and we can proceed as needed. But
how about a week from now, Missy? Can you continue him over to 1 week?
I will not be here a week from now.
Oh, 2 weeks? No, I don't want
We have cases set on July 31st at 10.
I'm supposed to be gone that date, so we've been trying to keep that docket date light, or it was just
Well,
kind of some paperwork thing.
Let's tell him. What's it take, Mr. Dean, to get from Emporia to here at a decent, safe speed, lawful speed?
Looks like August, maybe 14 would be the next.
August 14th would be the next day.
I don't want to go that far out on a show cause. Mr. Dean, you probably know better than anyone the driving time between Emporia and Eureka.
You're looking at right at 55 minutes, Your Honor.
Really, if you wanted to stay a while, he didn't violate any laws or get into any construction.
Now, there is construction. I take that back. There is construction on the south side of Emporia, so you're probably looking at an hour and 10 at this point.
Missy, put him on here. Do we have time to do this now, folks? I've got his probation officer waiting.
He's not. I'm trying to get him to law. I've sent him the link because he didn't have the link, so I went ahead and sent him. So he's not on here yet.
Well, he was supposed to be here at 11 in person, so I'm inclined to call this case, folks.
Judge, he's left me a voicemail too, so I could try to call him. Give me a second.
Let's just take somebody else up. I think I waste more time trying to be considerate or expedite matters than I do if I just call him. How about back to George Johnson? Did you get him here?
I think he's on the phone now.
On the phone with whom? You?
No, Blake, the phone rang in the background and I think he.
Oh, Blake went on the phone.
I think he's on the phone, but we do have two payer peers we could take up really quick, probably before we start the trial.
Well, and Mr. Jones is still waiting. Did you get her?
Right,
Who-
that's the trial, Your Honor. We'll do that.
That's the phone. All right. You guys tell me who you want to do and I'll follow along.
Payer peers, Your Honor, it looks like we had, and I don't know whether this is still, shoot.
When do those begin? 11?
Yes,
Yes,
which is
Your Honor.
already 11:24. We have Courtney Allen and
Okay.
Amethyst Stodd here for payer
All
peers.
right. We'll take up Allen on the record in GW 2026 TR61, State of Kansas versus Courtney, Juanita, Nicole, Allen, Paulie Dean for the state, Courtney Allen present. Miss Allen, did you get your case paid off by today?
I did not.
Did you understand that you were ordered to do so?
Yes.
And why did you not do so?
I had to take some time off work for a broken foot. I just need a little bit more time.
How much more time?
Like, I could do it in 60 days.
Mr. Dean, what do you think about continuing in this at the defendant's request for 60 days?
Give her the benefit of the doubt that she's had an injury, Your Honor. I won't oppose a 60-day continuance.
All right, this is continued at the defendant's request for 60 days. We'll review, we'll do another payer appear, Missy, about 60 days out. If you'd give us a date and time, please.
September 25th at 11.
September 25th at 11 a.m. That's your date to have that paid. Try to pay a little as you go to make a good faith effort, Miss Allen, or whatever you need to do.
Miss Allen, I have to create a record. It's called a journal entry. In this instance, the journal entry or continuance of your payer appear. All I'm going to do is indicate you requested a continuance. It was granted. And what was that date again, Missy? September
25th at 11.
to September 25th at 11. Would you waive your signature and trust that I will file that accurately on your on the party's behalf in this case?
Miss Allen, he asked.
In
if
other
you
words,
want-
Miss Allen, do you want to see the journal entry or the document that I prepared that says the court granted your continuance and moved it over
no,
to
that's okay.
September 11th, or are you going to trust me to prepare it and waive your signature on it?
You can waive my signature.
All right, thank you.
All right, you may go at this time, Miss Allen. We'll be in recess. You may go.
We also have Miss Bonilla, Catherine Bonilla.
All right, we're on the record in GW 2025 TR 235, State of Kansas versus Catherine Priscilla or Priscilla Bonilla or Bonilla. Are you here?
I am here, Your Honor.
How do you pronounce your last name? Is it Bonilla?
It's Bonilla.
Bonilla. Miss Bonilla, I show you still owe $249 on this payer appear. You weren't able to pay?
I'm sorry, Your Honor. I have since become homeless and I am trying to get back on my feet again. It's just been one thing after another, Your Honor. After my husband's deportation, my life has just fallen to shambles and I'm trying. I'm just requesting one more continuance, Your Honor, please.
How much time do you think you might need?
I want to say 60 days at the most. I will pay little by little starting today.
All right, Mr. Dean, your response?
No objection, Your Honor.
Want to set this over to 9:25 at 11 also, Missy?
That would be fine.
All right, have it paid or be back here September 25th at 11 by Zoom, Miss Bonilla.
Thank you, Your
Ms.
Honor.
Bonilla, do you also waive a signature? Did you hear what I advised Ms. Allen just a few minutes ago?
Yes, sir.
All right, and you waive that signature?
I do, sir.
Thank you.
All right, thank you, Miss Bonilla. You may go at this time.
Thank you.
You're welcome.
And then the other one was Miss Stodd.
Stodd, Amethyst Stodd, on the record in GW 2025 TR 460, State of Kansas versus Amethyst Dawn. Stodd, or is it Stodd or Stud?
Stout, Your Honor.
Stout, yes. Okay, Miss Stout, have you been able to pay your case?
No, ma'am.
Have you paid anything?
I have not been able to, no.
All right, I want to be understanding, what is the reason you haven't paid?
I have a lot going on as well, but that's no excuse because I'm able to pay it.
If you're able to pay it, at least pay something on it as you go.
Your
Also,
Honor, I'm gonna have a
yes.
different view on this particular case.
Okay.
And potentially ask the court to just consider putting it on a reporting probation. She entered a plea back in December on this case. We set March for a continuance of, March 27th. It was to be paid originally. On the 27th, we continued her out again to July 17th or so for an additional 90 days. We're pushing on 6 months with the court monitoring this pay or appear. Typically, that's time to move this to reporting probation, unless Ms. Stout can tell me that she can get this paid within like the next 30 days.
I can.
Let's do a pay or appear in 30 days. You're sure you said a while ago you thought you could pay it, didn't you? You got a lot going on, but did I hear you correctly when you said you could pay it?
Yes, I'll make it a priority to pay it.
Okay, well, it's $453 total, which is a chunk of change, especially when you have things going on otherwise, which we all do. But anyway, it's a lot harder for some. So at least show me every good faith effort that you've paid as much as you can. So
Going on to reporting probation also increases it by an additional $60 for a supervision fee. So if you can get it done prior to the next court date, that would be to your benefit.
yeah,
That's
that's
going to
right.
be a little over 30 days as well, because isn't that August 28th
at 11.
All right, August 28th at 11 a.m. I'm going to call your case again, look at your balance, and you better be here and tell me what's going on unless you've paid it, which is what the better position would be, is to pay it.
Yes, ma'am.
All right, thank you, Ms. Stout. You may go at this time.
Thank you.
You're welcome. Is that all the pay or appears, Missy?
That are here.
Okay, who's not here?
Well, we've got two, but you want to go ahead and take up this trial?
Yeah, let's do the trial, Your Honor.
That's Hirschberger.
Judge, I'm sorry, I do have George Johnson here now from the 10 o'clock. Could we just get a quick continuance on him to the September 25th date?
Well, I would have felt better about that if he'd been here on time. Start your video, Mr. Johnson.
And I have Robert Williams here as well now.
We are on the record in GW 2025 TR 651, State of Kansas versus George Vincent Johnson. Please announce appearances.
State of Kansas, Pines Ridge, Assistant County Attorney Paul Lee.
Blake Cooper on behalf of the defendant, George Johnson, who appears in person.
And why was Mr. Johnson not appear? Wasn't he the one told to appear in person?
No, Your Honor, this is an appearance date, just a status hearing.
All right, I have that here now. I show that he had originally been charged driving while suspended, driving without insurance, and speeding 78 and 65. This had been continued to today. At the defendant's request, he was here with his attorney. Given today's date, and now where are we on this, counsel? We've been doing this since first appearance, January 13th.
I understand, Judge, and Mr. Johnson has some information now for me, after I've talked to him this morning, that he's going to get to me that I can supply to the state. If we could have that September 25th date, we will have it resolved that day.
Mr. Dean?
Your Honor, I know this case has been around for a while, but I'm not going to oppose the request after having a conference with Mr. Cooper on it.
Missy, what time do you want to put that on the 25th?
10 o'clock, September 25th at 10 o'clock.
All right, Mr. Johnson, I'm continuing this at your request to September 25th at 10 o'clock. Condition of any bond you're on that you reappear at that time. If you don't reappear, I'm probably on time. I'm probably just going to issue a warrant for your arrest. You understand that, sir?
Yes, ma'am.
All right, stay in touch with your attorney.
Yes,
There'll be a
ma'am.
recess. You may go at this time, Mr. Johnson.
Thank you.
You're welcome.
And then Judge, I have Robert Williams here now, that PV that I accidentally told him to be on Zoom. He's here now.
All right, Mr. Williams, maybe your attorney, oh, well, I better announce the case. I'm getting ahead of myself here. This is Robert Scott Williams. Will be on the record now in two cases, GW 2024 TR 549 and 24 TR 579, each captioned State of Kansas versus Robert Scott Williams. Please announce appearances.
Here on the state of Kansas, appears by Assistant County Attorney Paul Green.
Blake Cooper on behalf of the defendant, Robert Williams, who appears in person.
All right, Mr. Williams has two cases. It's alleged in each of those cases he's violated his probation. These are cases from 2024. His probation officer has been waiting here all morning because she was subpoenaed in on a show cause on each of these. And Mr. Williams now appears at 11:35 after being told here to be at 11 and after having to be called by his attorney. So I want Mr. Williams to explain why he's holding this court case up. Why weren't you here on time, Mr. Williams?
I'm sorry, I ended up getting a piece of paper mailed to me saying that I had to be via Zoom, and
Okay.
I didn't.
Well, I understand how an office can get that kind of paperwork mixed up. I understand how you could be confused by it, but at the same time, I told you to be here at 11. So pay attention when I tell you something. And have you been reporting? Strike that. That's not a fair question at this stage. All right, I'm going to continue this. What's the closest date you can get me, Missy? Weren't you told to be here in person, sir? The letter told you could be here by Zoom, and that's what you went by. Okay. I'm going to tell you one more time. You will be here in person. And if your letter tells you otherwise, you better call your attorney and say, hey, I got this letter, but the judge said to be there in person. Are you sure that's right? Because attorneys are like judges. They have a lot of things going on, and they usually do impeccable work, but they're still humans, and once in a while things happen. And you need to confirm if something really bizarre like that happens, like the judge said I was supposed to be there in person. So I'm going to tell you next time, be there in person. And if they use their standard form that goes out and says Zoom, then you call him back, okay? We have an understanding?
Yes, ma'am.
All right. I understand how this could have happened, and nobody's really, I'm not going to put any blame on it, although I am kind of putting blame on you. All right, Missy, when can we continue this to the shortest available time frame?
Okay, well, I understood Mr. Dean said something about not putting anything else on July 31st. Is that correct?
Correct. So August 14th at 11 a.m. would be the shortest time frame that I could be available.
Okay.
That's a full month. You'll probably forget about it by then. Miss Morgan, do you have a position on this? What you wanting to do between now and then if we continue it that far out?
Your Honor, I will not be available on the 31st as well. So I will only be available. My next time would be the 14th as well of August. But I would ask that Mr. Williams call me going forward. Okay.
Have you been able to take any kind of test to make sure he's not using alcohol or illegal drugs or anything like that?
I have not heard from him since the warrant was issued or this was filed.
Judge, that's pretty standard. Typically, that's kind of what happens. But Mr. Williams, if the judge is telling you need to report, and Miss Morgan is saying you need to call it right after court, okay? You need to do it.
Yeah, I'll call her.
I'm
And I'm
sure
out in the alcohol monitor and everything, so I've been good. I haven't been drinking or doing any drugs or anything.
I don't need to hear that right now.
Oh.
he had a warrant to show cause hearing back February 13th, and he was found in violation. Do y'all know that?
Yes.
And he was revoked, was sanctioned to time served and reinstated for 12 months. Then he shows up late. All right, what do you want him to do? Do you want to spend time on him, Miss Morgan, with him being in this boat, or do you have other things you need to do where you don't need him tagging along if he's not going to take this seriously?
Your Honor, I'm available for the morning, so if you want to take this up, I'm fine with that, or we can put it off at a later time. I'm open to it. I'm sorry, I guess I'm not understanding your question.
Well, I get, Mr. Dean, we could just take this up now. We're running short on time, but we could take up the show cause now rather than setting it over for a month. What do you want to do?
Your Honor, at this stage, as late as it's got, we still have a trial where we have a gentleman who's been, as an attorney, has been waiting as well. I
Good
don't
point.
know whether we have stipulations on this or not.
And Judge, I'm sorry, my time is running short as well. I
have a jury trial on Monday, so I
All right, and
the
Mr.
afternoon
Jones
blocked out for
from
this.
the trial. All right, so continue to August 14th at the defendant's request. Be here at Missy is 11.
Yes.
And do you want to have him report to you, Miss Morgan, or is there any point in it?
Yes, Your Honor, I would like him to call me after court. And then, yes, he needs to be here in person on the 14th of August.
All right. But this was a DUI that he pled no contest to in February 2025. We found him in violation of probation and gave him a second chance February 13th to 26th. So I'm concerned about continuing this to October 14th, especially since he, well, anyway.
August 14th, Your Honor.
Be back here August 14th at 11 o'clock. And you be at the courthouse, Mr. Williams.
Yes,
if your
ma'am, I'm
attorney
sorry.
steps up like humans do, you call him back and say, "Are you sure?" Okay. All
I
right.
apologize for that, Judge. That was my oversight, and
He knew what I ordered though too. I understand. I get it. All right, Mr. Williams, contact Jessica Morgan as soon as this hearing is over. Give her a call. We should have her number.
Yes, ma'am.
All right. We're in recess. You may go.
Thank you.
And don't you be doing any driving under the
Nope.
influence of alcohol or drugs. Don't you even think about it. Ms. Morgan, test him. Test him as much as you can.
Yes, Your Honor. Your Honor, that's my last case. May I be excused?
Absolutely.
Thank you.
and mine as well, Judge.
Thank you, Jessica.
You may go. Thank you.
Thank you.
What about, I had a Shannon Cooper on Ethan Powell for a review hearing. How'd that come out? What do we do with that?
That was one of the other payer peers that failed to appear, but we were going to take him up after we take the trial up.
Same with Rivera. That was Blake Cooper's payer appear.
Yes.
Okay. All right. Thank you, Mr. Cooper. You may go.
Thank you. Have a good weekend.
You're welcome.
You
have a good weekend. I need to think harder on what I'm saying. All right. So now we're ready for a bench trial, and that is on, remind me, Hirschberger.
Andy T. Hirschberger, 26 TR 192.
Who also finally joins us after his attorney has worked hard to find him.
He's been here the whole time.
Yeah, he logged in about the same time I did.
I thought you had to go track him down.
No, that was Blake.
That was Mr. Cooper. It was tracking a couple clients down.
He had to go track down
Okay, so
George Johnson thought it was at 1 o'clock, and that's who he was trying to track down.
All right, clean slate, Mr. Hirschberger. Sorry about all of that.
No, that's okay.
I think what happened, maybe the other guy's clients delayed your hearing. Okay, let's call on the record GW 2026 TR 192, State of Kansas versus Andy T. Hirschberger. Please announce appearances.
State Kansas appears by and through Assistant County Attorney Paul E. Dean, Your Honor.
May it please the court, Your Honor, defendant appears in person via Zoom and with counsel Jeff Jones also via Zoom from a separate location.
Thank you. And I see Deputy Blake Fisher's subpoenaed here and honoring that subpoena. Mr. Blake, Mr. Dean, when you're ready to proceed, please let us know by calling your first witness.
Honor, the state would, I guess just for the record, waive opening statements. And the defense is doing likewise. I'd call Deputy Blake Fisher at this time.
Yes, we'll waive opening statements as well, Your Honor.
Thank you. Please call your first witness.
Deputy Fisher, would you please state your full name and title for the record?
Deputy Blake D. Go ahead, Judge.
You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you.
Sorry.
Please state your name. No problem.
That's been kind of crazy last 30 minutes. Deputy Fisher, would you please state your name and title for the record?
Deputy Blake D. Fisher.
And are you how long have you been a deputy with the Greenwood County Sheriff's Department?
Commissioned since January of 2021.
And when you say commission, does that mean you've completed the Kansas Law Enforcement Training Center?
Yes.
Education course?
Yes.
And through that training and education, have you been trained in regards to interdiction of vehicles who are committing traffic infractions?
Yes.
Is that including the traffic infraction of speeding?
Yes.
And have you had additional training since that commission date back in 2021?
Yes, field training.
All right. And back on March 19th of 2026, can you tell me what your duties were on that day, sir?
I was on routine patrol. I was going eastbound, and a semi-truck was going westbound.
And what highway or public roadway was this located on?
I was on US Highway 54 at the approximate 289 mile marker. The citation is wrong. It says the 282. I had a typo.
And how were you able to confirm that the 282 was incorrect and 289 was correct?
I watched my body camera.
And is 289, the mile marker 289, is that location where you made these approximate location where you made these observations within the corporate confines of Greenwood County, Kansas?
Yes.
All right. So you observed a vehicle traveling the opposite direction of you on US Highway 54. What observations did you make?
My in-car radar displayed the vehicle was traveling 80 miles an hour in a posted 65 mile an hour speed zone.
And is that the radar device, is certified?
Yes.
And prior to deploying that radar device, do you have any particular habit or custom in regards to testing that device?
I do a internal self-test of the radar itself.
And if the internal self-test does not fails, what do you then do?
I try to fix it until it does pass.
All right. But if it would not pass, would you take it out of commission at that time?
Yes.
Or out of service, I mean?
Yep.
And that particular radar device, have you been trained on that device, sir?
Yes.
All right. So you indicated your reading was 80, and what was the posted speed limit?
65.
And what type of terrain, if you recall, were you dealing with in this area?
Asphalt.
Was it a flat straightaway? Did you have hills?
I believe it was flat straightaway.
And once you obtained this reading, what did you then do, sir?
I activated the overhead emergency lights on my patrol vehicle and initiated the traffic stop.
And how did the vehicle respond to your emergency lights?
It came to a complete stop.
And did you approach and make contact with the driver?
I did.
And do you see the driver here with us today?
He is. He's in a screen that says Hirschberger 26TR192.
Did Mr. Hirschberger have a driver's license with him?
He did.
And were you able to properly identify him from that driver's license?
I was.
And were you able to properly identify Mr. Hirschberger today from the body cam video
Yes.
that you indicated that you previously observed?
Yes.
All right. Upon making contact with Mr. Hirschberger, did you have any conversation with him about the purpose of the stop?
Yes.
And what was that conversation?
I explained the reason for the traffic stop. He had said something to me, but due to the engine of the vehicle he was driving, I really am not able to recall what he said.
All right. Once you made that stop, what did you then do?
I went back to my patrol vehicle, checked the status of his driver's license. He showed to have a valid CDL, and then I issued him a citation.
All of his other documentation was in proper order, was it?
I believe it was, yes.
And so you issued him a citation for single count speeding?
Yes.
Same at that time you released him?
Correct.
Your Honor, I don't have any further questions.
Cross-examination, Mr. Jones?
Yes, thank you, Your Honor. Deputy Fisher, you testified that one of the things you do to try to make sure that the radar device is working properly is to run an internal check on the unit. Is that right?
Correct.
And when do you run that check?
At the beginning of my shift.
Okay. Now, do you utilize tuning forks at all in the testing of the accuracy of the radar unit?
Typically I do, but this date I was in a spare vehicle and I don't recall whether I did or not, so I'm not going to testify that I did.
Okay, but normally you would.
Correct.
If you were in a separate vehicle that different from what you usually drive, is that
correct? I was in a separate vehicle at this date, not my normal patrol vehicle.
Okay. Do you know whether that vehicle was equipped with tuning forks? Did you look for it?
I don't recall.
Okay. And when you do the internal test and or the tuning fork test, do you keep any kind of a log or record of performing those tests?
I do not, no.
Okay. So looking back at March 19th of this year, the date this citation was issued, do you have a specific recollection of performing either the internal check or the tuning fork tests?
I remember doing the internal self-test, yes.
A specific recollection of that particular day?
I do remember. On all my radars, I do an internal test if I cannot find the tuning forks.
Okay. But so would it be fair to say, though, that what you're saying is you have a habit and custom of doing it and you believe you did it on that day as opposed to having a particular specific recollection of doing it?
I know I did the internal test. The tuning fork test, I'm not going to testify that I did or did not, but the internal self-test I did perform.
Okay. Now, what make and model of radar were you using that day?
I don't recall. I believe it was a Stalker, but I'm not 100% sure.
Okay. What type of make and model do you usually use in your standard patrol vehicle?
I believe it's a Raptor.
Okay. So you don't know what make or model for sure that you had on the day you gave this ticket out?
Not 100%, no.
Okay. Based upon your training in let's say, were you given specific training in the operation of radar units?
Through my field training, yes.
Okay. And as part of that training, were you made aware that the manufacturers generally recommend that the units be calibrated approximately once a year?
Yes.
Okay. And do you know whether when the unit that you were using on this date that you gave this ticket, do you know when it was last calibrated prior to that date?
I don't have the records on that. The sheriff's office keeps the records. If it's not calibrated, then we pull the radar and aren't able to use it.
Okay, but you don't know when it was last calibrated?
I don't keep records of that. The upper management keeps records of that.
Okay. Would there be any reason why you couldn't have obtained the copies of those certifications and brought the most recent one, well, the most recent prior to this ticket date, that you couldn't obtain those from the department?
I don't see why I couldn't have.
Okay. Going back again to talk about your training on the operation of the radar units. As part of that training, were you informed that the manufacturers recognize that there's a certain margin of error inherent in the device itself?
I don't recall.
You don't recall whether you were ever told that there's approximately a 2 mile per hour margin of error if you're in motion, as you were in this case?
Not right offhand. I don't recall. That's been 5 years ago.
Okay. Do you have any recollection at all of a discussion of a margin of error?
Not that I recall.
Nothing further, Your Honor.
Thank you. Redirect, Mr. Dean.
No, Your Honor.
Okay, any further evidence? Mr. Dean for the state?
State would rest, Your Honor.
Okay. And may Deputy Fisher be excused if he needs to be elsewhere?
I'd ask, it looks like he's not on patrol at this point in time. In case the defense would offer testimony, I'd ask that he stay in case I'm involved for rebuttal.
Very well. Mr. Jones, any evidence for the defense?
No, the defendant's going to exercise his right to remain silent.
Very well.
Then,
Mr.
Your
Dean?
Honor, at this time, if Mr. Fisher wants to log off, he's more than free to do so.
Yeah, I have no objection to releasing the deputy.
Okay, Mr. Jones, you have any evidence or not? I think, sorry, I don't understand if you do, you don't.
We're not going to present any evidence.
All right, so both parties appear to have rested. No one wants to present any more evidence. Closing argument, if you want to make it.
Your Honor, I think the court's probably heard me make arguments on this topic enough times. If the court has any particular questions, I can. I know some of the issues that were pointed out, while those may have been, they're always an issue for argument. I don't believe they created a defense in this particular case, and the evidence would be unrebutted as to the speedy defense.
Mr. Jones, any argument?
Well, yes, Your Honor, I do have some. One is typically, the officer testified he typically uses the tuning forks. I think that's pretty standard. And here in this case, he was using a different unit, couldn't find the tuning forks. So I think that casts a little bit of potential doubt on the accuracy of the radar on that day in particular, since it wasn't fully tested prior to its use that day. We also have a question as to whether it was properly calibrated on a periodic basis. The officer did not know when it was last calibrated, did not obtain and bring the certificate of calibration, which any time you're trying to prove something and there's a writing that pertains to it, the best evidence rule says you should bring that writing with you to prove that. I think in this case, we've got questions about whether it was properly tested to be working right on that day that the citation was given, and also whether it was properly calibrated periodically and certified as working correctly. In that instance, you've got kind of 2 strikes on you. I don't think we need a 3rd strike to create reasonable doubt.
Your Honor, since I have the burden, I'd like to briefly respond.
Go ahead.
Your Honor, I believe this court will take judicial notice that there is, based upon past test or based upon the cases the court has heard, that there is not a requirement to use the tuning forks. I don't believe there's any case law that supports that. KHP, to my understanding, is, and to the testimony that's been previously brought to this court, has even, to my knowledge, stopped tuning fork usage. And the deputy did testify that if the certification was not kept up or it had not been certified as required, that the unit would have already been removed from service. And that's all, Your Honor.
Thank you.
If I might point out one other thing then briefly. Since the state has referred to prior cases and prior testimony, and I'm sure you've heard innumerable traffic cases, and you probably have heard testimony from other officers who did recall from their training that there is a margin of error inherent in the device of approximately 2 miles per hour if the radar unit is in motion. Now that can be plus or minus, admittedly, but I think when you've got a defendant who is presumed innocent until proven guilty, and you've got a recognized margin of error of potentially 2 miles per hour, that he should be given the benefit of the doubt that even if he's found guilty of speeding, it should be reduced by 2 miles per hour from what the radar read, because there is a reasonable doubt as to whether that was his actual speed versus the readout.
Well, thank you both, gentlemen. I make it my practice to do my humanly best to, in each traffic case, restrict myself to the evidence in this case. Although you are right, Mr. Jones, I have heard countless numbers. I've tried countless numbers. So I work very carefully to make sure I go by what I hear in each case. Now, Mr. Jones, defense counsel asked some very appropriate questions, although some of them did assume facts not in evidence, such as the margin of error, and that was one of those where it assumed the facts in evidence, but there was no evidence that there was that margin of error. So even if I could remember that prior testimony about margins of error, which I don't recall anything specifically, I would do my best not to accept that unless it was introduced into this case. But frankly, I do not, in all my cases tried, remembered. I can't believe I don't, but I just am not remembering what any margin of error would be. And because I think that question doesn't come up enough, oddly, Mr. Jones. I don't hear that a lot from Mr. Dean. That's one question that I don't hear a lot. I hear a lot about the tuning forks. Do they have to be calibrated? But based on what I have heard today, the questions, appropriate questions, good questions, did raise some doubt, but I don't believe they raised enough to put a reasonable doubt in my mind as to the speed and the testimony in this case. So I do find the defendant guilty as charged and would assess the scheduled fine. Another point I don't recall is whether that commercial vehicle affects the scheduled fine. That's not one I see very often.
I don't believe so.
I don't believe so either, Your Honor. I think only if it was in a construction or school zone would it alter the fine, or double it, basically. But there's no evidence or indication that it was in either obviously not a school zone. It's not out on the middle of the highway, and I don't believe it's a construction zone either. So I think it would be just standard fine.
Not marked construction zone, no evidence was presented of that.
I know I didn't hear that at all. But I paused because the citation in printed form has a place where the officers can circle 1, 2, 3, 4, 5 special categories, including construction zone, and he circled the middle one, commercial vehicle. But I apparently there's no special provision, or if there is, I'm not going to impose it, but because I'm not aware of it. But
Your Honor, I think the commercial vehicle notation is just due to the issues that can arise with the limitations on the federal masking laws.
Okay,
Commercial
there you go. There you go. That's probably right. All right. The scheduled fine for 80 and a 65 is $75 fine, 108 court costs, 183 total, and I certainly would give Mr. Hirschberger the benefit of having some time to pay that scheduled fine. So does the defendant need some time to pay that 183?
Yeah, let's do like 30 days if we can.
30 days. will be granted. Do we need to pay or appear, or just the clerk will suspend if he doesn't pay?
Yeah, Your Honor, I think you're correct on that. With it being a traffic infraction, it'll either be paid or there'll be a suspension notice. And with it being a commercial driver, I'm pretty certain it'll get paid.
Right. Now, the other issue, of course, is the right to an appeal, and I'll let your attorney talk to you about that. It's not an automatic do-over if you don't like my decision. That does happen with magistrates that aren't, as they say, law trained, but I've been an attorney for decades now, so mine would have to go to the Court of Appeals. Again, your attorney will explain all of that to you. If an appeal is filed, I would set an appeal bond of 183 so that depending the outcome, it's paid. He doesn't have to worry about that. We don't have to chase him down. We don't have to suspend him should he not prevail on the appeal.
And the appeal time frame would be 14 days.
14 days, yes. All right, that being said, anything further, Mr. Jones or Mr. Dean?
No, I asked Mr. Hirschberger if he wants to give me a call when we're done here. I can discuss the appeal rights that the judge talked about, and if you decide to waive any appeal, I can then give you information on how to get the fine paid the easiest way.
Since I got Mr. Jones here, it might be just the easiest if you could review this journal entry. I've obviously just got the case name, case caption, case number, the date we all appeared, your client appeared via Zoom, your retained counsel. Court made a finding of guilty on count 1 speeding. No allocution or anything of that nature. Court simply assessed 108 court costs. The thing was marked was a $75 fine for a single count 1. Court did give 30 days to pay. Nothing else is marked. I did notice the appeal rights were given 14 days. The appeal bond at 183. You approve?
Yes, I do. You can
Thank you, sir.
on that.
There's nothing further. Again, we are in recess. Mr. Hirschberger, Mr. Jones, thank you so much for and Deputy Fisher for your lengthy waits this morning. Our apologies for those, certainly, and you may go at this time.
Thank you, Your Honor.
Have a good one, everybody.
Thank you.
Thank you. And apologies to you, Mr. Dean, because you're...
A guilty plea only works if the defendant truly accepts responsibility. That principle became the focus of one unforgettable courtroom exchange when Alexander Thornton appeared ready to resolve his felony case through a plea agreement. At first, everything appeared routine. Thornton had signed paperwork with his attorney, and prosecutors were prepared to move forward with the negotiated agreement. But when the judge asked how he wished to plead, Thornton hesitated and suggested his decision depended on how much credit he would receive toward his sentence. The judge immediately stopped the proceedings. She explained that criminal defendants cannot plead guilty simply because they hope to receive a favorable sentence. The only proper reason to enter a guilty plea is because they actually committed the offense. If Thornton believed he was innocent, then the court would not accept a guilty plea simply to secure a better deal. Instead, he would have every right to take the case before a jury and require prosecutors to prove every element beyond a reasonable doubt. Defense counsel then created a detailed record for the court. He explained that prosecutors had offered a 3-year prison sentence through a negotiated plea bargain, and that Thornton had previously agreed to accept it. However, after another discussion outside the courtroom, Thornton told his attorney that he maintained his innocence. Because of that, counsel explained he could not ethically allow his client to plead guilty. If Thornton insisted he did not commit the crime, the plea agreement would almost certainly disappear, and the case would proceed toward trial instead. The hearing highlighted one of the most important safeguards in the criminal justice system. Judges don't simply approve plea agreements because both sides negotiated them. Before accepting a guilty plea, they must ensure the defendant understands every constitutional right being waived.